Good afternoon. We're here for another episode of Workplace Matters, your favorite workers' compensation related podcast. Here with my co-host Diana Castrillon. We're coming to you from the Celestial Broward County Bar Association studio. Diana?
Absolutely. These are great studios. They've just redone the entire room and we're trying them out for the first time. Very exciting. And today we're going to be talking to you guys about a case we've already discussed with you before, but the entire world has been flipped over once again. And so this is, of course, the case of Annalie Ortiz versus Winn-Dixie. And we're going to be going into just really how the court completely took a flip after they had already flipped our entire workers' comp statute of limitations world around just months ago.
Yeah, so by way of summary, the original opinion on the Ortiz case created what I thought was a very interesting analysis of our statute of limitations in workers' compensation here in Florida, but it was so just divergent from what we have been doing since 1994, or the analysis, I should say, since 1994, creating this very mathematical and, in my opinion, very complex way of analyzing the statute of limitations, which at the time I disagreed with.
And don't they know that lawyers don't do math?
Unless there's a dollar sign in front of it.
Well, that's for my bookkeeper. But definitely, yes, it created this kind of two-tiered system. There were multiple clocks running on the statute of limitations. There's a few law firms, friends of mine, who created actual flowcharts that they were incorporating into their files so that they were able to properly track statute of limitations. It used to be, you would put the 2-year mark on the calendar,
right,
and when the client would call and say they treated, about a year from then, we'd be, trying to call them 10 months in to make sure they had seen a doctor.
Right,
again.
That's what we do at our office too.
And that's basically how it had gone, as far as we knew, since 1994 up until several months ago, where this really kind of major shift occurred in the statute of limitations. And we had an entire podcast dedicated to that because it was such a huge impact to our practices. However, I guess that's no longer the case.
Well, according to the new Ortiz opinion, I don't know if you want to call it Ortiz 2, The Empire Strikes Back. I don't know what you want to call it, but this opinion that came out December 23rd of last year essentially vacated or set aside that original opinion. And by the way, there was some discussion as to, at the JCC level for certain, whether that was even precedential, right? Whether that was even law. And there were several JCC opinions that said, yes, this is because of the way that it was analyzed and ultimately entered into, that became the law as far as statute of limitations. Several JCC opinions applying that analysis to the statute of limitation in their cases, but that's no longer a valid opinion.
Right. And essentially what this decision that did just come out December 23rd. So it was for those of us who celebrate an interestingly Merry Christmas, because now here we go from keeping track of these two clocks on our cases to essentially the court doing a complete flip and saying, number one, they set aside the entire previous order and they're replacing it with this final compensation order. And so essentially what they're saying is that other thing we did for several months, it's like it never existed. It certainly was not valid as far as they're concerned. And they go into a very factual analysis. It's a complete shift because the prior decision, in my opinion, was a lot more, they didn't really look at the facts as much as give like a legal analysis of what the statute of limitations, what the statutory language means. And they really dove into when it stops, when the clock begins, what is the provision of a benefit such that the clock would start or begin? And it was a true legal analysis and a pretty convoluted one, in my opinion. But this one, number one, washes that entire thing away and now says, no, we're just going to start a fact-specific investigation when we're looking at statute of limitations.
And that's exactly what this opinion does. Ironically, the original opinion and this opinion both essentially overturned the trial court's opinion in finding that the statute of limitations was a valid defense and a bar to the petition that was filed on this case. The original Ortiz opinion, again, no longer good law, right? Said no, the statute of limitation had not run. This one says the same thing, but more, as you say, fact specific. You want to go into a little bit of that, because I think it's really important what they say here.
Yes. So the thing was with this case is this is a really kind of interesting injury. It's not what we typically see in the world of workers' comp. This is not an orthopedic injury or such that we're kind of used to seeing. This is an individual who, as a result of an injury, suffered so much damage to their kidney that it actually had to be removed. And so this person had really significant medical issues that followed as a result of the loss of the kidney. And so she ended up having UTIs on a pretty frequent basis that all stemmed from the original problem. And so the workers' compensation carrier's authorized physician had been treating this patient for urinary tract infections on a almost annual basis since having removed her kidney as a result of the accident. And so in this particular occurrence, the time frame that they're looking at was a 2019 time period. Essentially in January of 2019, the claimant had gone in for care that had been paid for by the carrier for urinary tract infection. Thereafter, she goes in August, 2 times in August 1st of 2019 and August 12th of 2019. But this time the doctor's office, for reasons unknown.
Right, because it's not in the opinion. It's not in the appellate opinion. I don't know if it's in the underlying JCC opinion. I doubt it.
I'm sure they would have brought it up.
Right. But for reasons only the doctor's office knows, the doctor's office asked for the claimant's personal health insurance card. And it was that entity, the personal health insurance, the group health insurance, that was billed for not only that 2019, but I think a 2020 visit as well, right?
They may have been. There were certainly billed for the 2 August 2019, which are the most notable because the claimant did not have authorized care again until August of 2020. And so if we base it on the January 2019 date, which was the last time that the carrier was billed and paid for care, then certainly an August 2020 date sounded like the statute of limitations had run. The carrier was unaware.
Right, the carrier had the servicing agent in this case had no notice. The employer had no notice that she had gone back to the authorized doctor to receive care that ostensibly would have been covered otherwise had they been placed on notice. But for the doctor's decision, again, for reasons we don't know, we were talking before the recording of this particular pod, maybe it was just an internal policy where the doctors just asked for insurance cards or whatever it was, but the carrier had no notice. So the defense that was asserted was the way we analyze this, we look at last provision of benefit. Is it 2 years from the date of accident? Is it 1 year from the last provision of benefit? We have no notice. We didn't know. We being the servicing agent. So they had no notice. The doctor billed because the doctor billed the group health, and that's what brought us here. They filed a petition, and that's what we're talking about as far as Ortiz 1 and Ortiz 2.
Correct. And essentially what the court hinged its ultimate decision and our current law as it exists today was on the concept that they cited to a case that I was just looking for, and I think, Henry, you had it highlighted.
Right.
So can you read that?
Yeah,
it's interesting.
And I think this is very interesting, and it's not a case that I've ever seen, but that doesn't mean anything. There's probably thousands of cases that I have not seen, but I'll just quote: "This court repeatedly has held that who gets billed has no legal bearing on the tolling question," and that's CMCO Labs Inc. versus Pearson 424 Southern 2nd. That's right, Southern 2nd, 898. This is the first DCA case from 1982.
But it's interesting because it really does. That's the factual decision that the court made. They said, regardless of the fact that the doctor's office may or may not have billed the appropriate entity, regardless of the fact that the carrier had maybe not been placed on notice due to that doctor's error, the claimant cannot be prejudiced as a result of that. And ultimately, they found that the statute of limitations had not run on this case, not because of the tolling provisions that we had previously been looking at with the Ortiz 1 case, but rather because the plain old regular statute of limitations that we all knew and grew up with essentially had not run because treatment had been rendered within a 12-month period from that August 2019 date. But, and that's the ultimate ruling in Ortiz. And because we have a short time here, we wanted to kind of jump to what we found to be the most intriguing. I think Henry sent me this case and the immediate reaction was, whoa, did you read that concurring opinion?
Right. Savage. I guess
Savage.
I think that's what I said. The one of the concurring opinions goes on to say, I write to emphasize that like this concurring opinion, Judge Tannenbaum's concurring opinion that follows is not the opinion of this court. These concurrences have no precedential value.
You could literally hear the whip. Whoosh, wow,
That-
what was that? When you're concurring with someone, what's the word for that? There's a term for that, right? Where you're telling them, oh yeah, I agree with you, but just so you know, you're wrong.
Right.
And that's basically what this concurrence says. And it's basically, and I love where it was placed in the opinion because it was placed before, physically before the then concurring opinion of Judge Tannenbaum. Now, notably, Judge Tannenbaum had been the individual who wrote the original Ortiz opinion, right, who created this kind of 2 clock concept. And, I will say Judge Tannenbaum, he doubles down on
he's not backing off.
He is not backing off
from his analysis. And he goes on further to caution not only practitioners, but also judges.
The court.
Yeah. That the way he analyzed it is right.
I will say, I kind of wish that the way he said it in this concurring opinion of Ortiz 2 is the way he would have said it in the original opinion.
I agree.
Because this is so much easier for me my small brain to understand. Whereas the first one I felt was just like this total cluster of information. This one was like, oh, wait a minute. That actually makes a lot of sense. And he really just focuses on the word tolling and what tolling means.
Right.
And if you look at the definition, what tolling means, and when you think about it, it means we place it on hold. The clock was running and then we stop it. We toll it. And then stuff happens and life happens. And then it starts to run again, but it picks up where it left off. And what he's essentially saying is that the 2-year statute of limitations that exists in workers' compensation cases continues to exist, that there's nothing new here, but that when the statute, when this action occurs,
the provision of a benefits, it tolls or stops the running of that clock.
So that clock just never stops running. And so the 2 years came up again. So his argument is, regardless of whether it's January or August or whatever you want it to be, at the end of the day, there was a 2-year window. So whether we look at January as the date or August at the date, this was well within that 2-year window. Again, this is, as the judge above said, not the opinion that matters. But I will say, gosh, I wish you would have said this the first time around, because this was so much clearer, in my opinion. Notwithstanding what Tannenbaum has said, Justice Bilbrey has made it very clear that this has no precedential value, and we are back to square one and the factual analysis that the court will take on our statute of limitations cases.
I wonder if they talked about this over a cup of coffee or lunch, and how'd that go?
I don't know. See, I read things like a reality series. And when I see this, all I can picture is the cup of coffee being thrown across the table. I certainly hope that was not the case. And I doubt that was the case, quite frankly. But I thought it was pretty interesting to see a judge basically straight up say in an opinion, beware of what you're going to read next, because it doesn't mean anything. And he's wrong. So pretty wild. But anyway, I guess the point of the story is that
we're right back where we were pre-Ortiz 1.
Where we started.
At least as of the moment.
As of the moment, that's correct.
Right. There certainly doesn't preclude a trial court judge to follow the Tannenbaum erudite analysis of the 2 1-year statute of limitations. So it remains to be seen. New opinions, not even 30 days. Remains to be seen how the trial court implements this particular analysis in their cases.
But I want to believe that this was a nod to the court saying, hey guys, just keep things as it was. If it ain't Baroque, don't fix it.
Although I looked at it differently, I looked at it as a message to the legislature. You may want to take a look at this to make sure that practitioners, injured workers, employers, carriers, their servicing agents really understand the statute of limitations. So I think that the legislature, in my humble opinion, should probably look at this for perhaps some rewording or restructuring.
As a claimant's attorney, I never like when the legislature looks at our law, quite frankly. However, it's yet to be seen. And if it does happen, then obviously tune in and we will let you know. We'll keep you abreast of all the latest cases, the interesting things that shift our practice every single day. So we hope to see you at the next episode.
Take care.